Good evening, friends. In the series of AIB exam preparation for the forthcoming February 5th examination, I am trying to keep all the old question papers with respect to the subject wise in the posting in the YouTube, so that the students who are appearing for the exam can they can use these things. Okay. I have done with respect to the Constitution, CPC and CRPC. Today I am going to use the old question papers for last 10 years on Indian Penal Code with a question and answer. Hope this will be useful to all those students, all those advocates who are appearing for the AIB exam. Thank you. The first question: the casting coach in Bollywood, the Indian film industry, is an example of sexual harassment. Harboring an offender who has escaped from the customer or whose apprehension has been ordered, if the offence be the capital, is dealt under section 216 of IPC. Harboring a criminal whose punishment is a capital punishment is covered under section 216 of IPC. The maxim actus non facet reum nisi mens sit reo means there can be no crime without guilty mind. The famous pronouncement of the Delhi High Court regarding the constitutional validity, section 377 of Indian Penal Code, reversed the Supreme Court in Nas Foundation versus Government of India, Shabana Asmi. The answer is Suresh Kaushal versus Nas Foundation. Suresh Kaushal versus Nas Foundation. This 377 is with respect to the gay. Under which section of the IPC professional negligence is often invoked against the medical professional in case of a alleged professional negligence? It is a section 304A, while 304B is for the bridal death, 304A is for the medical negligence. In a case, A offers bribe to B, a public servant, as a reward for showing A some favor in the exercise of B's official function. B accepts the bribe. So in such case, what is the relevant section? It is the section 161 of IPC, in which it can be considered that A has abetted the offence defined in the section 161. The committee which led to the passing of the Criminal Law Amendment Act 2013 was headed by Justice J.S. Verma. Z, under the influence of the madness, attempts to kill X. Is Z guilty of an offence? Has X the same right of private defence which he would have if Z were the sane? Z has not committed any offence as per the section 98 of IPC, and same right of private defendants to X if Z is mad. Section 98, offence committed by unsound minded person. As per the section 53 of IPC, the word injury denotes any harm whatever illegally caused to any person on the body, mind, reputation, or all of the above. Answer is all of the above. Section 53 with respect to the injury, physical, mental, or a reputation. The provisions of Indian Penal Code applies also to any offence committed by any Indian citizen in a place without or beyond India, any person on any ship or aircraft registered in India, wherever it may be, any person in any place without or beyond India committing the offence targeting a computer resource located in India. All of the above are considered to be the offences. Voluntarily throwing or attempting to throw acid is an offence punishable under section 326B of Indian Penal Code. A is at work with a hatchet. The head flies off and kills a man who is standing by. Here, if there was no want of a proper caution on the part of the A, his act is considered, it is not an offence. A, with the intention of the causing Z to be convicted of a criminal conspiracy, writes a letter in imitation of Z handwriting purporting to be addressed to an accomplice in such a criminal conspiracy and puts the letter in a place which he knows that officers of the police are likely to search. A has committed an offence under section 192 of IPC. In which of the following case the offence of sedition was in issue? Offence of the sedition was in issue with respect to the Queen Empress versus Bal Gangadhar Tilak, Nehrendu Dutt Muzumdar versus Emperor, Kedarnath Singh versus State of Bihar. All of these were considered offence of sedition during the British time. Deliberate and malicious act intended to outrage the religious feeling of any class by insulting its religious or religious beliefs is an offence under section 295A. Under section 82 of the Indian Penal Code, nothing is an offence which is done by a child under the age of 7 years. Child under the age of 7 years is considered there is no offence. Aibe versus Dudley and Stephen stands for the principle of killing an innocent life to save his own is not a defense and not necessity cannot be pleaded as a defense against a murder. Aibe versus Dudley and Stephen. The provisions relating to dowry is given under section 304B of the IPC. 304B is the bridal death. Which of the following section is designed to curb infanticide? Section 315 of the IPC is designed to curb the infanticide. If a person undergoing the life imprisonment attempts to commit murder and hurt is caused thereby, he may be punished with a life imprisonment, death, imprisonment, or all of the above. All of the above is the right answer. The punishments to which offenders are liable under the provisions of IPC are death and imprisonment of life, rigorous imprisonment and simple imprisonment, forfeiture of the property. These are all the punishments under the IPC. All of the above. M. Norton rules form the basis of the law for insanity. M. Norton rules are for the insanity. A places men with a firearms at the outlets of a building and tells Z that they will fire at Z if Z attempt to leave the building A. Is it wrongfully restrain the Z or wrongfully confines the Z? It is both. Wrongfully restrains the Z and confines the Z. A incites a dog to spring upon Z without Z's consent. If A intends to cause the injury, fear or annoyance, A uses the cumulative force to the Z through the dog. A causes cattle to enter upon a field belonging to Z. Intend to cause and knowing that he is likely to cause the damage to the Z's crop. A has committed a mischief. X strikes A. A is by this provocation excited to violent rage. Y, a bystander intending to take the advantage of A's rage and cause him to kill X, gives a revolver into A's hand for that purpose. A kills the X with the revolver. Here A is liable for committing the murder and Y is liable for abetting the murder. So both are committed offences. A and B agreed to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which in the course of fencing may be caused without foul play, and if A while playing fairly hurts B, A commits no offence. This provision is there under the section 87. Under section 87, a consent harm created due to the concept of any play or any type of entertainment, it is not an offence under section 87. The provisions of the right to the private defences are given under the section 96 to 106 of the IPC. There are various types of the rights of the private defences are there. Please remember, section 96 to 106 is private defense. When two or more persons agree to do an illegal act or an act which is not illegal by legal means, such an agreement is designated as a criminal conspiracy. The provisions regarding the seditions are given under the section 124A of the IPC. Sedition is under section 124A of IPC. When two or more persons by fighting in a public place disturb the public peace, they are said to commit an affray. An affray is creating a public nuisance or public something creating a nuisance or a disturbance to the public. It is an affray. Promotion of a class hatred is given under the section 153A. Class hatred is under section 153A of IPC. The distinction between the 299 and 300 was made clear by Melville J. in case of a Reg versus Govinda. This is the case culpable homicide amounts to murder 299 and 300 Reg versus Govinda. A person instigates any person to do an offence or illegal act or omission attracts section 107 of IPC. Instigation under section 107 of IPC. Uttering words with a deliberate intention to wound the religious sentiments will be dealt with 298 of IPC. 295A is for the insulting the religions, creating a enmity. Wound the religious is 298 of IPC. A is at work with a hatchet. The head flies off and kills a man who is standing by. If there was no want of a proper caution on the part of A, his act is excusable and not an offence. This is covered under the section 80 of IPC. The same question is given in a different way. In-camera trial is conducted in the cases charged under the section 376 of IPC. That is related to the rape cases, molestation, rape cases. In-camera proceedings are to be conducted. Mahatma Gandhi was jailed and prosecuted by British regime in 1922 at Ahmedabad under section of 124A for the sedition and disaffection to the government. Abetting the commission of suicide is given which section of IPC? It is neither 7, 8 or 9. So in such case, none of the above, you may have to refer to the IPC section in the exam. A finds a purse with money not knowing whom it belongs to. He afterwards discovers that it is belong to the B and appropriate to his own use. A is guilty of a criminal misappropriation. A knows that it is not his money and A also knows that it is somebody's money. So knowing somebody's money using is a criminal misappropriation. Who is a lawful guardian? A lawful guardian is a person who is in law represent the minor, a person who has been appointed by the court, who is a person who has been authorized to represent an unmarried daughter. All these are considered the lawful guardians. What is meant by homicide? It is a killing of a human being by another human being is a homicide. Adulteration of the food or a drink is punishable under the sections 272 and 273. Section 272, 273 of IPC deals with the adulteration of the food or a drink. Maximum punishment for waging a war against the government in India under IPC is death sentence. Offences relating to the elections are introduced in the IPC by a subsequent amendment in the IPC. Rupan Bajaj versus KPS Gill is a famous case of outrage the modesty of the woman. KPS Gill was the DGP in Punjab and Rupan Bajaj was a IPS officer. So she filed a case. It was a question of a outrage modesty of the woman. Outraging the modesty of a woman is punishable under section 354. 354, outraging the modesty of the woman. Section 463 of Indian Penal Code deals with the forgery. 463 deals with the forgery. Criminal intimidation is explained in IPC under the section 503 to 506. There is either theft or extortion, then it is called the robbery. This section was enacted to meet the cases of the dowry deaths, that is section 498A of the IPC. The rule is that penal statute must be constructed is strict construction of the law. The various words used to denote mens rea under IPC are defined in the code itself, which are voluntary, dishonesty, fraudulent and reason to believe. The chief elements necessary to constitute a crime are it's a human being, it is an evil intent, it is an injury to the another human being or the society. All these are considered the chief elements of constitute the crime. A surgeon knowing that a particular operation is likely to cause the death of a Z who suffers under a painful complaint but not intended to cause Z's death but intending in good faith for Z's benefit, performs the operation on Z with Z's consent. A has committed no offense. This is under section 88 of IPC. Under the 88 of IPC, any medical act to help a patient with the concept of the patient is under section 88 of the offense. Even that act harms the patient. The distinction between the section 299 and 300 was made in the Reg versus Govinda case. The provisions related to the compoundable are provided under the section 320. Compoundable offences are under section 320. Compoundable offences are those whose punishment is less than 7 years and who can be compromised, but they are not of a criminal nature. In the light of the Criminal Law Amendment Act 2013, which of the following statement is correct? The word rape in 375 of IPC 1860 has been replaced with the sexual assault, and the rape is now a gender neutral offence. The amendment has fixed the age from the consent for consensual sex as a 16 years. All these are amended in the section 2013. This was also kind of a after effect of the Nirbhaya case. The offence of stalking upon a second or a subsequent conviction is cognizable and non-cognizable. Normal stalking can be a cognizable, is a non-cognizable, but offence of a second time it is a cognizable but non-bailable. In kidnapping, the consent of the minor is wholly immaterial. The committee that led to the passing of the Criminal Law Amendment Act 2013 was headed by Justice Verma, Justice J.S. Verma. The right to private defense is available when there is no time to have recourse of the public authorities. Again, this is between the 96 to 106 sections. To establish the section 34, a common intention must be provided but not overact is required to be proved. The person taking part in the commission of an offence have been divided into two classes. They are the principal and abettors. Prosecution for the offence of a defamation can be initiated on the complaint of the aggrieved party. A issued a warrant to a police officer to arrest the P, but the officer arrests the Q after the due inquiry believing Q to be P. Here P is liable for the criminal negligence. Here P has not committed any offence by virtue of section 76 of IPC. He has not intentionally done, so he has not committed any offence by virtue of section 76 of IPC. Durham doctrine means an accused is not criminally liable if his unlawful act is the product of the mental disease or a mental defect. Durham doctrine, anybody with a mental defect or mental disease commits any crime, it is not considered as a criminal, he is not liable. De minimis non curat. De minimis non curat means trifling acts do not constitute an offence. Trifling acts is the minor acts, funny acts, jokeable acts which will not have much harm. They are not constitute as an offence. P and Q agree to commit the theft in our house, but no theft is actually committed. Here P and Q are guilty of criminal conspiracy. They join to do something. Action is not taken, but they have thought of doing something, that is a criminal conspiracy. Ramu is suffering from a disease of the heart. Rahul, his hair rushes into his room and shouts to hear, "Your house has destroyed by fire," intended thereby to kill the Ramu. Ramu dies of the shock. Here Rahul is liable for the offence of a culpable homicide because he knows that Ramu will die because he is a weak heart, and Rahul intentionally shouted and Ramu died. This is a culpable homicide. Section 299. Or obtained a sum of 50,000 rupees from D by putting the D in fear of a death. This is called the extortion. Whoever causes the bodily pain, disease, infirmity to any person is said to have inflicted the hurt on the victim. Personification at the election is an offence under Article 171D of the IPC. Although election rules and regulations are separate, still it is a crime under IPC section 171D, the personification in the election. Voting, somebody's voting right to by some other person. Raman, having found a key of Raju's house which Raju had lost, commits the house trespass by entering Raju's house after opening the door with the key. Raman has committed the offence of house breaking. Who among the following is not public servant? Liquidated, civil judge, secretary of a cooperative society, none of the four. So secretary of the cooperative society is not a governmental body, so it's not a public servant. Putting or attempting to put a person in fear of death or grievous hurt in order to commit extortion is covered under the section 387. Extortion under 387 of IPSC. F invited C to have a fix of his heroin. Each filled his own syringe and injected each other several times one night. Next morning, F died on the question of a causation. C must be convicted for the manslaughter because C has fixed his heroin for the F, and F died because of C. So C must be convicted for a manslaughter. Literally, mens rea means guilty mind or wrongful purpose, criminal intent or a guilty knowledge, and willingness to do a crime. All of these are a mens rea. Mens rea is not essential ingredient in case of revenue acts, public nuisance, criminal cases which are summarily moved. All of this, for this, mens rea is not an essential ingredient. Actus non facitium nisi mens rea. The intent and act must both concur to constitute the crime. Cheating, thereby dishonestly inducting the delivery of the property or making alteration or destruction of a valuable security, is dealt under the section 420. cheating 420, 416 to 420 related to the cheating. Promoting enmity between the different groups on the grounds of the religion, race, place, birth, residence, language, and doing act prejudicial to maintain the harmony is an offence under 153A of the IPC. There are certain cases are there releases 295A, 263, 153A. So we have to be referring to the case where exactly the question is related to. The gist of an offence in a meeting of the minds is 120A. A places men with the firearms at the outlets of the building and tells B that they will fire at B. B attempts to leave the building. It is a wrongful confinement of a person. Adulteration of the food is covered under section 272. Voluntarily causing the grievous hurt to deter a public servant from his duty is cognizable and non-bailable. A obtains a property from Z by saying that your child is in the hands of my gang and will put to the death unless you pay. This is actually extortion. It is a kind of a kidnapping, but it comes as an extortion. Obstructing the public servant in discharge of his public function is a bailable offence. In the IPC, nothing is an offence which is done by a child below 7 years. Right of a private defence of the body extends to the voluntarily causing the death if the offence which is occasionally exercise the right of reasonable causes apprehension that death will be caused. Under section 498A, cruelty means it is mental as well as a physical torture. What is the offence where the preparation itself of an offence is punishable? It is a dacoity. The preparation itself is an offence if a dacoity is planned. In Rex versus Veda, the point of the decision between the section 299 and 300 are defined properly. A has a sexual intercourse with his own wife aged about 14 years with her consent. It is also considered the offence of the rape because she is a minor. Friends, these are all the questions with related to the IPC which came in last 10 years AIB examinations. Hope this information will be useful. In the next session, I'll be going through the various questions given under the Evidence Act. So till then, please go through this and get a benefit. So at least 3 to 5 questions from this are expected. If we get at least 3 to 5 questions in each previous questions, that will be around 30 to 40 questions. So rest of the questions, even if you can guess also, you will get a minimum 40 to 50 marks. Okay, this is my intention of putting the efforts to bring this video to you people. Thank you very much. If you like, you please like it, share it with other friends who are appearing for the AIB.